Hi, everyone, and welcome to another question and answer session live. My name is Samara Belitzky, and I'm an employment lawyer at Samfiru, Tumarkin. I'm working out of our Ottawa office, so I do assist mostly people in Ottawa, but all over Ontario, as well as BC. I'm going to be here for the next half an hour to answer all of your questions with respect to employment law, workplace issues, anything you've been experiencing regarding issues at work, whether it's related to less and less related to COVID, but we're still getting lots of questions related to vaccines, masks, workplace safety. So any questions regarding those things, happy to answer them, whether it's severance, terminations, changes to your workplace conditions, potentially, whatever you may have on your mind, whatever you're dealing with, feel free to send in your question. Happy to answer it. Like I said, here for the next half an hour or so to answer all of your questions. As always, I've prepared a few topics of things that we've been asked a lot over the last little while, issues that we've seen in the news that would be of real assistance to most of you who are watching. I'd much prefer to answer your questions, so please send your questions in and I will answer them as they come in. I see that I have a few questions coming in already. There is one thing that I wanted to make sure that I discuss today, so I'll talk about that one topic first while more questions come in, and then if we don't have time for the other topics, so be it. Otherwise, we'll get to the other issues later. The first thing that I wanted to talk about is layoffs. We've been seeing a lot of layoffs in the news over the last, I'd say, few weeks, but it's actually seems like more like a few months. And there's been lots of layoffs that have been announced by all different companies, different tech companies, and most recently in the tech industry, there were lots of layoffs done by Shopify. There's lots of layoffs happening right now. So what does that mean as an employee? What does it mean as an employer? So there's a lot of questions that we get about this. And it's really important to know that, generally speaking, when we're talking about these mass layoffs, they are terminations. Oftentimes we get questions about what's the difference between a layoff and a termination. A temporary layoff is really the proper use of the word layoff, is temporary in nature. It's something that we've seen a lot of over the last few years during the pandemic, and it isn't something that an employer can do as a right. It isn't something by default that's lawful for an employer to implement a temporary layoff. Now, that's something we've talked about a lot over the last few years. I won't get into that right away, right now, unless people do have questions about a temporary layoff. But when we're dealing with terminations, and when you hear the term mass layoff, that really is a termination. And the reason that we call it a mass layoff is because under the different provincial regulations, there is a term that basically corresponds to that, but it's a mass termination. And when we're dealing with mass terminations, there are very particular items that need to be complied with by the employer. So if it's a regular termination, for example, in Ontario, if it's a regular termination, the Ontario Employment Standards Act outlines bare minimum entitlements that an employee on a without cause termination or regular termination would have to receive. And it's always done by length of service under the Employment Standards Act only. Again, I'm talking about just your bare minimum termination entitlements right now, not your full severance, just your bare minimum. When we're talking about the bare minimum entitlements owed under the Employment Standards Act, as I mentioned before, it's done by length of service for a regular termination. When we're dealing with a mass termination of 50 employees or more at a time, then there are different entitlements owed to the employees. And depending on your length of service and depending on how many employees are being let go, like I said before, at least 50, but there are differences between 50 versus 200 employees at any given time. At that point in time, if that were to happen, there are additional entitlements that would be owed. So for example, somebody might only have a few years of service and normally for a regular termination only be owed a minimum, a starting off point of 3 weeks of termination pay or 3 weeks of notice. But if they're let go as part of a mass termination, let's say it's 75 employees who are let go in one shot, then that person would be owed 8 weeks as a bare minimum starting off point. So there's quite a significant difference, and there could be quite a significant difference between just somebody's bare minimum termination entitlements under the law of the Employment Standards Act. Again, we're talking about only a starting off point, only a bare minimum, but there could be quite a big difference between that if it's a regular termination versus what that might be in a mass termination, a mass layoff situation where 50 or more employees are let go at one time. So it's very important to understand that as an employee, if you're being let go as part of a mass termination, just your bare minimum starting off point will be higher than what it would normally be if it was a situation where less than 50 employees or just yourself would be let go from the company. Just like any termination, it's always important to get advice from an employment lawyer. So I'm giving information right now. It's good for people to know that your bare minimum starting off point will be different in a mass termination versus a non-mass termination, a regular termination. But again, that's just your starting off point. That doesn't mean that's all you're owed. Most of the time, an employee, when they're let go, will be owed much more than their bare minimum under the Employment Standards Act. That entitlement under the Employment Standards Act, depending on which province you're in, every province has its own employment standards legislation, but it will always outline a bare minimum. That is just, again, I'm going to sound like a broken record, it's a starting off point. So you're owed at least that amount in the Employment Standards Act. But it is not a limit, it is not a ceiling, it's just a floor. And from there, most people are owed their full severance. So it's very important to get anything that you're offered reviewed by a lawyer, even within the context of a mass layoff, a mass termination. Does not work any differently. You have time to get your package reviewed by a lawyer, make sure you're being offered what you should be, and if you're not, have us assist you in going after your full severance and making sure that you get what you're owed. Don't let an employer pressure you into signing something on the spot or signing something or agreeing to something before you're ready, before you do your due diligence and get your proper legal advice. Always get it reviewed by an employment lawyer first, because 9 times out of 10, if not 10 times out of 10, you're not going to be offered as much as you should be. So I'm going to get to the questions. We had a lot of questions over the last little while about mass terminations and mass layoffs. So I wanted to make sure we had time today to address that. I'll also mention that on our firm website, if you go to employmentlawyer.ca and you go to our blog postings, we actually have a few articles and a few blogs about mass terminations and how it works with respect to the increased termination entitlement. So if you want more information about that, you can go to our website, again, employmentlawyer.ca, and check out those blog postings to give you more information about that. But it's never a replacement for legal advice. If you're being affected by a termination of any kind, you should always get legal advice from an employment lawyer first, so that we can review all of the severance package, all the relevant documents, and make sure you're getting what you should get. If not, help you get what you are owed. So I'm moving on to some questions now. I see some questions coming in. Keep them coming in. We have another 20 minutes or so here, so send your questions in. I'll get started here with P. Chen on YouTube, who says, I was given a warning letter stating I am rude when transferring calls to employees in a call center environment. However, I believe I was retaliated for speaking up at employees' survey meeting. And then it continues on, I asked for evidence of where and when I was rude and none was given to me. Do you have to accept this letter? Great question. So essentially it's a warning letter. It's a disciplinary measure that's being implemented by your employer. They do have the right to implement different disciplinary measures depending on the conduct that was engaged in. In this situation, you have every right to know exactly what the instances are that they're talking about. This is a very specific thing that they're accusing you of. They're saying you're being rude. That's misconduct in the workplace. And you do have the right to be given examples of it. Who was I rude to on what day? What did I say? Because again, the purpose of giving you this warning is to help you improve, right? It's to give you a warning that you may have done something in the workplace that's not acceptable and it needs to improve. And likely your warning letter says if it doesn't improve and it continues to happen, it could lead to additional discipline and up to and including a termination of your employment. So what that means for you is that you have to be told exactly what was rude. What did you do that was rude? You should be asking that question, but you should make sure you're doing it in writing. So send an email to HR or to whomever was the person that brought this to your attention. Ask in writing for examples of what the conduct is that they're trying to address. You need the details. And then if they don't provide you with that information, it's very hard for them to try and use that against you in the future. You also should be putting in writing that if you feel like this is reprisal, you said it's retaliation, the legal term for that is reprisal. When you speak out in the workplace and you try to assert a legal right that you have every right to do, and you are disciplined because of it, you receive negative treatment because of it, you're terminated because of it, any of the above, then that's what's called reprisal. If you feel like you're being, your employer is committed reprisal against you, you need to put that in writing as well. And that will help protect you moving forward. Now, if you haven't engaged in any misconduct to your knowledge, they can't point you to examples, and you've outlined in writing that you feel like this is an act of reprisal, that will protect you in the future so that if you do receive a further warning, if they continue down this road of disciplining you and eventually they try to terminate you for cause without giving you any notice or severance, then you have this correspondence and you have this chain that you can go back on to help support your legal position. So it's very important that you take these steps now. Hopefully it won't go any further. Hopefully nothing more will come from this, but you need to do it just on the off chance that something does come from this, so that if there ever is a situation where they try to terminate you for cause where cause doesn't exist, meaning they're saying you've engaged in very serious misconduct, justifying a termination without notice or severance, well, you can fall back on this correspondence to say, no, actually, I disagreed. You couldn't provide me with any examples. You couldn't point to how I was rude, what kind of misconduct I specifically engaged in. And that will be of assistance to us if we're going to assist you in going after your severance. So I know that was a two-part question. I'm just going to the rest of your question. Do you have to accept the letter? So there's no kind of accepting or not accepting. The employer can put that letter in your file. The employer can give you that letter. You don't have to agree with it. You're going to put in writing that you disagree with it, and that will also be in your file. So you'll have both versions of events and both positions in your file if ever this goes any further. In terms of accepting it in writing, you don't have to sign it. Your employer can provide it to you. If you disagree with it, you don't have to sign it. They may ask you to sign it to confirm receipt. So not that you're agreeing to the letter, but just that you agree that you've received it. If that's the case, it needs to state specifically on the warning letter, something along the lines of, I acknowledge receipt, I confirm receipt, and then your signature. If it doesn't say anything and they just want you to sign somewhere on the letter, you shouldn't do that, because that could be misconstrued as you agreeing or admitting that you did something wrong. Similarly, if it says, I acknowledge that I engaged in this conduct, or it says anything other than just, I confirm receipt, I agree that I've received this letter, anything other than that, you should not sign it. And when in doubt, have it reviewed by a lawyer. I've assisted people in the past with these issues where they've received warning letters, they've been told they're going to be put on a performance improvement plan, and they've been asked to sign. In those circumstances, they get in touch with us. We have a consultation. We go through all the documentation. We make sure that there's no issue with it before signing. More often than not, there is an issue with them signing, and I'll advise them not to sign. That doesn't stop the employer from putting it in the file, from putting you on a performance improvement plan if they want to. They have the discretion to do that, but you don't have to agree to it in writing, okay? And in fact, it's better that you don't, because then they can use that against you later on. So I hope that answers your question. This is an issue that comes up fairly often, which is why I wanted to give a more detailed response on this. If anybody, who's watching is dealing with this issue, please keep these, this guidance and this advice in mind, because if you sign something, even if you don't realize what you're signing, it's too late after you've signed it. You're stuck with it. Your employer will say, you agreed to it, you signed, you agreed, and they're going to use it against you in the future. You cannot dispute it. You cannot argue that the letter is wrong or that something was, the version of events of your employer is actually not accurate, and fight it. You really can't do that as successfully if you've signed it to indicate agreement. So you have to be very, very careful when these things come up. And I always recommend speaking with an employment lawyer before doing anything, especially signing any sort of document that the employer gives you. Okay, I have another question here from JBK on YouTube, who asks, can your employer tell you when you have to take vacation time? And then I think there's a few other questions here. I work at a center for over 15 years, 7 hours a day. Now she told us it's going to be 8 hours a day. Is she allowed to do that? Okay, so you have a few questions here. I'm going to go one by one. The first question, can your employer tell you when you have to take vacation time? The short answer is yes. Employers have the discretion to decide when employees take their time off, their vacation time. Most of the time as an employee, when you request your vacation, you ask for approval, it's approved most of the time. But the employer doesn't have to approve the time that you want off. They actually can dictate when you take your vacation. So they can say when you can't take it, when you can. They can black out certain times a year for business reasons that, during that period, nobody can take a vacation. There are things that the employer can do. It's within the employer's discretion to decide when you can or can't take vacation. We might sometimes think that's unfair or disagree with it, but from a purely legal perspective, they are allowed to do that, okay? The next question that you had was that your hours are going to be changing from 7 hours a day to 8 hours a day. So sometimes employers are allowed to make minor changes to the terms and conditions of employment. For example, if they're wanting to change your schedule a little bit, they can. But again, there's a limit. They can't make significant changes and impose them on you without your consent. So in terms of a 7-hour day versus an 8-hour a day, if it's every single day and they're now asking you to work an extra hour every single day, depending on the circumstances, that could be a significant enough change that you can refuse it. It could be a significant enough change that they would actually need your consent, your agreement, to be able to implement that change. And if they don't have your agreement and they try to force it on you, you would have the ability to assert a constructive dismissal claim. Now, a constructive dismissal is something that happens when an employer changes a fundamental term of your employment without your consent. So it's not just any change. First of all, it has to be a permanent change. So if it's temporary, it won't trigger a constructive dismissal argument. It has to be permanent. If it is permanent, it has to be significant. So for example, if it's compensation and your employer is reducing your compensation by 30% per year, certainly that's a significant enough change. Demotions are other examples of significant changes. When it comes to scheduling, if let's say you're used to working the day shift and the employer wants to now switch you to the night shift, that would also be a significant enough change to trigger a constructive dismissal. And when we're dealing with constructive dismissals, what we're talking about is a situation where the employer has made a change that's so significant that you cannot continue working, that the employment relationship has essentially come to an end because you simply cannot accept such a big change. And in that situation, it would be akin to a termination of your employment. So even though they're not saying to you outright, you're fired, you're terminated, the end result is the same. And what are you owed? Well, you're looking at your severance. So in a regular termination, you're owed your termination entitlements. And that would be the same thing for a constructive dismissal. So in this scenario, this is a situation where I'd say it's not the most significant change in the world, but it certainly is significant enough that depending on the circumstances here, you may very well have that constructive dismissal argument and be able to refuse that change and not allow the employer to impose it on you. You have to get more advice on this issue, JBK on YouTube. We certainly can discuss this further offline. If you want to contact me, you can go to our website, employmentlawyer.ca. You can go to my profile and get my email address, and you can email me directly. When we're dealing with these types of changes and possible constructive dismissal situations, it's really important to get ahead of it. Anytime you're in a situation where changes are being made to the terms and conditions of your work, you need to speak with an employment lawyer right away to figure out whether this is something that you can push back on. If so, how can you go about doing that? What's the best way to do it? And we would assist you kind of behind the scenes and then get involved at a certain point when it's the right time, because you need to make sure that if you're in a situation where the employer is making these changes, forcing these changes on you, that you express your refusal right away. Time is always of the essence when dealing with changes to your work conditions, with possible constructive dismissal arguments. It's always important to express your refusal right away. If not right away, then very, very quickly, because if you don't and you keep working under the new terms of and conditions of work, you will be deemed to have accepted them. And then there's nothing you can do. You can't go back on it and refuse it. You know, if you work under the new terms and conditions for, let's say, 3 months, and then after 3 months you decide you don't like it, it's too late at that point. You're already going to be deemed to have accepted those changes. So it's really, really important, if you're in a situation where your employer is making changes, get advice, get in touch with us, get advice from an employment lawyer right away so you can find out where you stand and what you can do to push back on this. This happens all the time. You don't want to be in a situation where you wait too long and then there's nothing you can do about it. You have to act right away. So in your situation, JBK, get in touch with me, because, you know, generally speaking, it looks like you could have a legal leg to stand on here to push back. The other circumstances will be important. So we'd have to discuss all of the surrounding circumstances in order to assess what your options are. And if there is something you can do here to push back and to assert a constructive dismissal claim, we are happy to help you do that. We help people with this particular issue all of the time. Now you had one more question here. So your last question, I was denied EI because I wasn't vaccinated. Did things change since restrictions were lifted? So the government directive, so the federal government directive to Service Canada is that they are not to approve EI benefits for anybody who is currently not working because of the fact that they're not vaccinated. So in the face of a mandatory vaccination policy at work, the employee didn't get vaccinated, they were put on a disciplinary leave of absence or terminated. If that's the case, the government has told Service Canada not to approve EI benefits for those people, and Service Canada has conducted itself accordingly and complied with that directive. Now, what we just saw come out of the social tribunal recently is somebody who appealed that. And in that most recent decision, there's only been this one decision so far. They overturned Service Canada's determination. And what they found is that there was no cause for termination and the person should be owed EI benefits. Now, this is one case. Every single case is different. Every single set of circumstances is different. So depending on your situation, it's hard to say what would happen. But the fact that there is now this decision that overturned Service Canada's determination to deny EI benefits for somebody who wasn't vaccinated, it does give a precedent in order to, support a position that maybe you should receive EI benefits. So if you're looking for a way to appeal EI's decision, to appeal Service Canada's decision and receive EI benefits, that decision would be where I would start, because that decision would support your position. Again, The facts might be different. Your situation might not be the same as the situation in this case that I'm talking about, but that would be your starting off point, because that's the only possible case that could be of assistance. The government hasn't changed their directive, to my knowledge, with respect to what they've told Service Canada to do with these types of claims. So since the restrictions were lifted starting at the beginning of October, they did lift restrictions with respect to travel, for example. You no longer have the mask on a plane or on a train, and there aren't any vaccination mandates or conditions in place for entering Canada. But in terms of EI benefits, this was a directive. So it wasn't something that was put in place. There wasn't a law that was put in place, like the mandates that we just talked about, the other measures that were lifted, like the masking. Those were actually put in place by law. Service Canada was given a directive by the federal government. So they're very different things. And to my knowledge, that directive hasn't changed, at least not as of yet. I have a question from Melinda on YouTube. If I work for a US-based company, am I subject to their laws and considered an at-will employee? My contract doesn't say anything about this. It depends on what's in your contract. So if your contract doesn't talk about what law applies to your employment, it will depend on where the employer is located, and it will also depend on where you're located. So your question here, Melinda, doesn't mention where you are working from. So there could be an argument that the law that applies to you and that applies to your employment is the law of where you're working from. So if, let's say, you're working from Ontario, maybe it's Ontario. It will depend on what's in the contract, as well as the type of work that you're doing. So if you wanted to get more information about that, feel free to contact me offline and we can look at this a little bit further, because we'd have to review the contract and we'd have to look at a few other items in order to assess which law might apply here. So I have a question here from George on Facebook. My wife was recently placed on an unpaid leave from her position after filing a complaint about her supervisor's behavior. Are they allowed to do this? Her supervisor is still working and it doesn't seem like her complaint was taken seriously. Absolutely not, George. They are not allowed to do that. If your wife filed a complaint, they are allowed to separate the employees, so the complainant versus the alleged perpetrator. And oftentimes, as an employer, it's a very good practice to make sure that if somebody's filing a harassment complaint or a bullying complaint, that you separate the workers for the time being while you investigate the situation to make sure that any alleged harassment or bullying cannot continue to go on while it's being investigated. So that's a very good practice, and one that I encourage all employers to implement. That's not what it sounds like is happening here. What sounds like here is that there was some sort of reprisal committed against your wife for having filed this complaint. She certainly shouldn't be on an unpaid leave. If there is an investigation ongoing where the employer determines that somebody can't be at the workplace and they need to be put on a leave, it should be a paid leave. And in this situation, it's not clear to me why your wife was put on a leave at all. So certainly they're not allowed to do that. This is the kind of situation that could be treated as a constructive dismissal. The employer is forcing your wife, preventing her from working and not paying her. That would be a constructive dismissal. That is something that they're not allowed to do, and your wife certainly has legal recourse. I'd be more than happy to assist her with this, George. If you want to get in touch with me, you can contact the firm, you can contact me directly. Again, you can go to employmentlawyer.ca and go on to my profile. All of my contact information is there. I'd be more than happy to assist both of you with this situation. Absolutely unacceptable. And certainly there are things that can be done to make sure that either if your wife wants to get back to work, she gets back to work with back pay from the date she was put on an unpaid leave, or if she doesn't want to go back to work, we pursue this as a termination and get her a severance package. So definitely get in touch. Get in touch right away. The more time that passes, the weaker your legal argument gets. So get in touch with us right away so that we can assist you with this. We're just at the end of our time here. I have a few questions, unfortunately, that I haven't gotten to. So I'm going to answer one more question, and then if I haven't gotten to your question, feel free to either email us at help@employmentlawyer.ca and somebody will get back to you. We also have another question and answer session on Tuesday. Monday's a holiday. Normally we would have one on Monday, but because it's Thanksgiving, we have one on Tuesday afternoon. So I'll answer one more question and then we'll finish for today. So Alexander on YouTube says, I was on stress leave from work. I provided all medical documents, etc. After a year, my employer fired me for an unauthorized leave. Is this a human rights issue? Short answer is yes. This is not making sense to me, quite frankly, Alexander. It's really not a good practice for an employer to engage in this kind of conduct. So if you provided medical documentation, they'd have no reason to say you're on an unauthorized leave. If you provide medical documentation that substantiates the need to be on a medical leave, your employer has to accommodate you and hold your job for you, essentially, so that you can go back to work when you're cleared by your doctor to go back. The only thing I can think of here that could have possibly happened is if they contacted you for updated medical and you ignored them, that could possibly be how they're considering it to be an unauthorized leave. But barring anything like that, I don't see how they would be able to substantiate this legal position or fire you for being on an unauthorized leave. So certainly there's a few issues at play here. One is you'd be owed severance for sure, as long as they had substantiating, supporting medical documentation that supported your leave continuously while you were off. As long as they had that, if they let you go, you're owed severance, absolutely. And secondly, it is a human rights issue as well. So there are two kind of moving pieces here. There's the severance piece and the fact that they let you go completely because of, if not partially because of, your leave. And under the human rights legislation, being on medical leave, even if it's temporary, it's considered a disability. It's protected by the Human Rights Code, and employers are not allowed to treat you differently, discriminate against you, or fire you because of your disability or your medical leave. So that's definitely a big problem here for them as well. So get in touch with me, Alexander. Again, I've provided, how to get my contact information. Go on our website, get my contact information, get in touch with me. We'll take a closer look at this, but this is not adding up. So it sounds like your employer has really engaged in some serious illegal conduct here, and you certainly have legal recourse for, like I said, severance and human rights damages here. I'd be more than happy to help you. So we're going to end at that today. Again, we have another question and answer session live on Tuesday with my colleague, Madalena. So please tune into that. And if I didn't get to your question, send in your question on Tuesday or send it into help@employmentlawyer.ca. So that'll be it for me today. Thank you everybody for joining and for sending in your questions. And I hope that everyone has a wonderful long weekend. Take care. Bye-bye.